Sir, you're charged with deadly conduct. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On April 2nd, 2025, in Harris County, Texas, a law enforcement officer was dispatched from an apartment complex and spoke to a complaining witness who said that she was laying in her bed and was awoken by her son, the defendant, screaming. And then she heard 2 gunshots go off in the apartment. The complaining witness then got out of bed and took the gun from the defendant, hid it, and called 911. Upon arrival, the law enforcement officer recovered the weapon, along with 2 fired shell casings and 2 fired slugs matching the caliber of the pistol fire. Upon contact with the defendant, the law enforcement officer noticed the odor of alcoholic beverage and that the defendant was wet while fully clothed. The defendant stated he had
Defendant was what?
wet while fully clothed.
Wet while fully clothed. Okay.
Sure. The defendant stated he had been drinking alcohol and smoking marijuana and that he fired the firearm in the apartment.
Did he really say he poured water on himself because he was paranoid? That's not a defense, it's a red flag. And remember, alcohol, weed, a loaded gun, and paranoia don't mix. The court's not just listening, they're calculating risk.
The defendant said he was wet because he dumped a bucket of water on himself. The defendant stated that he was paranoid at the time.
Mr. Collins, I'm sending you for a drug test. I want to know what, if anything, was in your system. You're to come right back. I will appoint you a lawyer today, but you're not to use alcohol or illegal drugs. If I find that you're using, it's not going to go well for you. You're also not to be in possession of weapons. Do you understand? So, do you guys have a rip done on this case? Do we
Yes,
know
sir.
whether she wants him back at home or no?
I made contact with the claimant owner, however, she did not wish to talk with me about the incident after.
She want to talk to you?
No, Your Honor.
Okay. Don't be in possession of weapons, Mr. Kiles. You know, I don't want to have to put you in jail and make your bond high. I don't know if you have anyone in this life that is prepared to pony up $5,000 to $10,000. So when you're out there in the free world, if you don't have anyone that's going to, pony up that money for a bond, you'll be stuck like Chuck in there. So be careful. All I want is my city safe. You understand?
Yes, sir.
Okay, so what we'll do is I'll appoint you a lawyer today. Or do you have the ability to hire a lawyer, or would you like a court-appointed lawyer?
You can appoint me a lawyer, and I may consider hiring one if the understanding is not
I
understood.
just want to know whether you want a court-appointed lawyer or not.
Yes,
I
sir.
can
Yes,
appoint
sir.
you a lawyer
Yes, sir.
today. I'm sending you for a drug test. I want to know what, if anything's in your system, come back, and then I'll have a lawyer waiting for you.
Okay.
Okay, please.
Judge, financial affidavit or no?
Good morning, Judge. I'm here on Katrina Keys. You had her on docket for Friday for a bond violation, but she needed to come in and talk to you anyway, so she came today.
I'm sending you for a drug and alcohol test right now, ma'am. But unacceptable. You're on bond for DWI, and you now you're allegedly consuming alcohol.
No.
Yeah,
I spoke with the SCRAM people and she said that was not it. It's not an alcohol violation. She doesn't know if
alcohol
my,
was detected during both tamper events. But they cannot be confirmed because of the nature of the tamper.
I haven't had a drink since I was arrested, Your Honor. I've done everything this court has asked me to outside of looking for a job and everything. I have had no problems. I've called SCRAM about my device. Because I have neuropathy swelling once it goes down. So she said it was loose. I asked them, the only thing that I did on Saturday and Sunday, which can be confirmed by my GPS monitor, I went to my son's basketball game. I left my house, went to my son's basketball game, from the game back.
Let's
I
do
have
this.
not done anything.
Lisa, do you mind sending her for a test right now, please? I'm going to send you for a test. You
Okay.
can come back. Do you
No problem.
understand?
Mhm.
We'll do.
This is where the judge draws the line. No more SCRAM bracelet excuses. If you're on bond, the court isn't looking for stories, they're looking for stability. Real question, should bond violators get second chances, or is that just asking for trouble? Let me know below.
Oh, sorry, her drug test was presumptively negative, Judge.
Ever test positive again, I'm going to keep you.
Judge, it was a SCRAM temper.
If you ever tamper with the device again, I'm going to keep you. I'm doing everything in my power not to revoke your bond. Do you understand? I don't care what it is. If there's a problem with your device, you need to go have it switched out, Go get it looked at, but I will not entertain any more excuses from you. No tolerance. Do you understand?
Yes.
Okay, all right.
Did she address my, curfew? My lawyer was supposed to ask you about my curfew because I got a job and I started today. And the job is from 5 p.m. to 6 a.m. at Igloo. And I have the letter saying that I've been accepted for the job.
Does she have something open elsewhere as well?
She had a deed to provide open out of Austin County, Your Honor.
Still open?
It's not still open. I'm not sure if she pled it or what happened, but looks like she's on probation now. For that one, I've also.
You're on probation for DWI. You've not picked up another DWI. I don't want you driving in the middle of the night.
I'm not driving. I'm not driving.
That was just on March 26th, I believe, Your Honor. Is when she pled for when that case was resolved. The year probation.
I resolved that case. And I
You still have an open DWI and you picked up another DWI.
I didn't. I haven't done anything since before.
Don't talk. All I know is that you have a probation for DWI, you have an open DWI. The last thing I want is another death on my streets. And I'm going to do everything in my, I tell Pete, everybody tells me what I want to hear here.
I'm not.
And then when they get out there,
Before I took the job, I spoke with my lawyer. I
keys.
have someone that works there and they shuttle and I can get a ride. But right now, like I'm having a problem with getting my lights were turned off. The phone was turned off. I'm worried about monitoring. So I've been working very hard to find a job. This is the only job that I found and I need to work to survive, to pay my bills. I have to work. And with the background that I have, it's been hard for me to find a job regular 8 to 5. This is the only thing that was available. And then I made sure that there was a ride or a shuttle. They work in shifts. So 5, 6 people in my neighborhood work there. So I've secured a ride to and from work.
proof of employment that you actually have a job working
I
there.
have it. My lawyer have it and I have the email
Have you
right
met
here.
with your lawyer? I want to see actual proof that you're working there. And then we'll put a GPS monitor on you,
I have a monitor. I have GPS monitor already.
exact address, so that we know that you're going to and from work. If you deviate in the slightest, and I don't care what it is, that'll be your 3rd bond violation, and I'm going to lock you up. I will deem you a public danger and make your bond sky high. Do you understand?
Yes.
Okay.
The-
Excuse me, I'll have you get with your lawyer and then they can get with pretrial.
And I start today. It starts today at 5 p.m., which is why she had me come today.
Okay,
So-
I'll have you get with Ms. Reedy. She can get with pretrial. You guys can work out the details.
All right, thanks.
Judge, would you like me to email that proof of employment to you or to pretrial?
No, to Felicia. And I
Okay.
don't know if you have her email address. I'll see if I can get it for you.
Okay, please. I'll see if I-
Give me a second. I'll chat it to you. Hold on. a
Okay,
second.
thank you, Judge.
Good morning, Mr. Williams. Sir, you're charged with theft. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Judge. On July 15, 2024 in Harris County, Texas, a defendant was observed on surveillance video entering a pawn shop accompanied by a female, a toddler, and a baby in a car seat carrier. The defendant was observed putting down the baby, picking up the projector, and concealing it behind an item on the next aisle. The defendant then returned to the baby, picked up the baby, and then picked up the hidden projector and concealed it in the car seat. The female completed a transaction at the counter, and the defendant left with the item in the car seat without paying, passing all points of sale. The defendant was identified by his Tennessee driver's license photo by the complaining witness. The value of the item sold
20 days old, missed court 3 times, and now a theft with a baby seat involved. The judge is done playing. And that warning, I'll make your bond hit the clouds. That's not drama. That's strategy. Miss one more, and it's game over.
was $2,000 or $2,099.99.
Do we know if they got it back?
I do not, does not say in the DIMS. So we need just a moment, Your Honor, to,
We can worry about it later.
yes, Your Honor.
Mr. Williams, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to go back to this pawn shop. You've also missed 3 different times. If you miss, excuses go in one ear, go out the other.